The Honorable Justices of the Supreme Court of the State of Iowa, hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. We are here this afternoon for 4 cases. The case of Norris versus Paulson and City of Des Moines is hereby submitted without oral argument. Our first of 3 oral arguments today is State versus Reuben Schooley, and the parties appear to be ready to go. So, Ms. Nye, you may begin as appellant.
Good afternoon. May it please the court, counsel. Melinda Nye on behalf of Reuben Schooley, who appeals from his conviction and sentence for a single count of child endangerment resulting in bodily injury. On appeal, he's challenging the sufficiency of the evidence supporting his conviction that his actions on that day don't exceed his parental right to discipline his child, and also argues that the district court improperly considered the sentencing recommendation from the guardian ad litem. The state prosecuted Mr. Schooley for child endangerment under 726.61b, alleging that he intentionally committed an act or series of acts which used unreasonable force, torture, or cruelty, which resulted in bodily injury. The charges were based on Reuben's punishment of AS, of his 10-year-old daughter, she was just a couple weeks shy of 10 years old, for stealing from her siblings. He spanked her with an open hand over her clothing on her buttocks. He slapped her sort of in the head, also with an open hand, and yanked on and removed an extra shirt she was wearing, and sent her outside on a summer evening in June. The spanking and the slap on the head caused momentary pain, and somehow the best anyone could figure out, when removing the shirt, he inadvertently scratched and left a red mark on her clavicle area, or 2 red marks. These actions don't rise to the level of unreasonable force, torture, or cruelty, and do not exceed Reuben's parental right to discipline his child.
Let me ask you, when we consider the sufficiency of the evidence, we're stuck with the jury instructions that have not been objected to. I don't think these were objected to. Is that correct? Right.
Got in was agreed to.
And so, as I look at 14, 15, 16, it really puts in the hands of the jury, doesn't it, sort of this unreasonable force or torture or cruelty. I mean, it says you have a reasonable, a parent may use reasonable and timely physical punishment, but then the reasonableness is sort of handed to the jury too, in sort of a multi-factor approach, the gravity of the misconduct, the amount of force used, corrective or not. And then bodily injury just means physical pain, which it seems pretty well established here that at least some physical pain. So I'm struggling with, given these instructions and their sort of open-endedness, and how we could say that there wasn't enough evidence.
That's always the problem, of course, in a sufficiency argument, but sometimes the jury gets it wrong. And there's no allegation that the jury instructions were incorrect, but sort of as a matter of law, given that Iowa has this, not a presumption, I guess sort of a presumption, that parents are allowed to physically discipline their children, even if not everyone agrees with that idea, but it has to still rise. There has to be some threshold, and so a spanking on the bottom that causes temporary pain is the quintessential allowable, sort of permissible, socially acceptable spanking or punishment within the realm of the parents.
What about the photos that show bruising?
That it was clear that, I think from the testimony at trial, that was clear that those bruises were not caused that day by Reuben's actions. They were fading bruises, And AS testified that those bruises were caused by stepmom, Tessica, who had spanked her with a paddle within the week before, several days before. And so the officer who looked at the bruises said these were not fresh bruises. He also notably didn't even observe red marks left over from the recent spanking, only observed these fading bruises. And it was AS who said they came from Tessica's punishment at an earlier time. And Tessica ultimately, she admitted that she spanked her with a paddle and reluctantly eventually agreed that that's probably.
Schooley's admissions, the head thing is not a disciplinary thing. He said that. And he said, and it wasn't appropriate for discipline, and that the head thing was out of a fit of anger. Isn't that sufficient in and of itself? These are his own admissions.
Words, so there's a few things there. With, he's trying to sort of piece this together. His statements are that, and, between what he said to the officer and his, further explanation at trial, is that this was the slapping upside the head is something his father did to him, and it's a punishment he received. And so it was an instinctive punishment, sort of.
Is there anything in the record to show that she actually did anything wrong? He said for being a thief, taking her siblings' things, but the siblings said we didn't have anything taken. So wasn't it just emotional trauma and not really discipline?
I'm not sure. I'm not sure where in the record that the children denied having anything taken. I know the one daughter was questioned and wasn't tuned into what was going on that day. But AS told the neighbor, and she testified that she was punished for stealing. Tessica said, she couldn't remember exactly what had happened, but she was supposed to be in her room, and instead she was downstairs in the kitchen getting into something. And she refers to this sort of chronic problems. This family has been struggling for years to blend. We've got, stepmom coming in with 3 older children, and Reuben with AS, who's younger than these other children. And they're trying to blend these families and figure out how to discipline. And clearly we can see, but the way this plays out when DHS gets involved, they were doing, everything they were doing was ineffective. She's supposed to be grounded to her room. She's clearly not in her room. She gets sent outside. Like they're going to therapists, and they're trying to correct this long-term behavior of lying and stealing.
How much could the jury rely on Mr. Schooley's admission that he spanked AS every other day?
I'll say that evidence is, he was questioned and he said that AS testified that she was spanked every other day, but that Tessica did most of the discipline.
Also testify that he spanked her probably every other day? Didn't he tell the officer that?
And so he estimated that. I don't know, how you put all that together. But I know that.
This is for a jury.
I think still, even if he spanked her every other day, the testimony was his spanking. Well, there's a couple things. He was charged with committing this offense on June 12th, not the whole year and a half before.
On or about. I think that there's a jury question even about that. But when it says on or about June 12th or whatever the date was, and there's evidence of maybe things that happened that week before that was allowed in, was the jury allowed to consider at least, within the last week? I'm not sure what on or about would mean.
I think on or about, the state could have charged a range. If they wanted to get to the last 2 years, they wanted to get to the last 3 months, like they could have charged a range. On or about is, when you have an event that happens and you can't prove the exact time or date, but it happened around Thanksgiving or it happened in, that's on or about. They still allege that day.
I agree with you as a general matter, but there was no dispute that this was about, if this was only limited to June 12th, the specific date, they knew the day that the officer came to the house. It was clearly June 12th. So does that on or about allow the jury to reach at least, evidence of that he might have spanked her every other day? So, 3 days, today, 2 days ago, 4 days ago, those kind of things, which could have led to then the bruising on her bottom.
I think I think that it's not that sort of open-ended, like how many, again, how many days can the jury consider? The jury was told, go back and read the instructions that say on or about June 12th. There was no, the state suggested saying, no, you get to include a few days before or a few weeks before, and that wasn't what happened.
To the other issue that is definitely, and before I ask you to make your argument on it, I want to make sure I'm teeing it up correctly. My review of the record shows that on April 12th, your client made application for a GAL. And then the jury trial and the sentencing happened, and then an order was entered very soon thereafter. The GAL submitted a report for the court on July 13th of 23. So your client asks for a GAL, and in his application filed on April 12th, he says that he is entitled, or the child as a victim, he calls her victim, is entitled to have a guardian ad litem to represent her interests in this matter. And then paragraph 2 says it would be in the best interest of the child to have a GAL in the case. So then when the GAL submits her report, it appears to me it's buyer's remorse. Help me understand your argument why, oh my God, how could they have listened to what the guardian ad litem said? Help me.
The guardian ad litem, certainly anybody could have asked for the guardian ad litem to be appointed. I think when you look at the course of this, Reuben was trying to do, what was in the best. He was trying to protect AS, that despite these allegations, he loved her dearly and wanted to reunite with her. They did, you look at sort of behind the scenes, they did everything DHS recommended, things got better. So guardian ad litem is properly appointed. He wouldn't have had good grounds to resist it if somebody else. But when it gets to the sentencing,
On the fact he asked for it.
absolutely, no, I don't. So, but he agreed that she should be within her proper role as a guardian ad litem. And on appeal, we're arguing that her sentencing recommendation exceeded her proper role under the statute.
The sentencing, the PSI was, or the GAL report was included in the PSI. Is that right? And from my review of the record, there was no objection at the time of sentencing to that. Is that right?
At the beginning of the sentencing hearing, the judge said, you've had a chance to look at the PSI. Do you have any corrections or additions? And there was no objection at that point. But actually, if you look at Mr. Schooley's allocution, he objects to the substance of the GAL's sentencing recommendation that she's basing this on. The abuse started up again, and he vehemently disagrees with the underlying facts that ultimately she's removed.
The lawyer made no objection to the inclusion of the GAL report in the PSI. And the argument that you're advancing that this isn't allowed by statute, that argument was also never made at the time of sentencing. There was no motion to exclude the GAL from providing the report. Is that right? That's correct. Okay.
I know these often are raised as ineffective claims, and that's, can't do that on appeal.
Very type problem here. I mean, objections to the process of the sentencing proceeding are waived if they're not raised.
It is different in part because the district court explicitly relied on the guardian ad litem statement. And so, our argument is that puts it in an improper factor.
I don't necessarily agree with you on that. I don't think he relied on it. I think he said something about as in the GAL report. I think there's a difference. Just because the GAL report lines up with what the judge wants to do doesn't mean he necessarily relied on it, does it?
He's specifically citing to, just as the GAL said, this, he's not going to be deterred. Probation is not going to deter him. And that was her whole argument. I recommend this specific sentence because of deterrence, because of the severity of the crime, and for protection, she listed.
Donald's made a comment that the report being attached to the PSI was not objected to. And am I correct that my summary or review of the evidence is also such that counsel also did not object to county attorney reading the GAL's report?
There wasn't at that time. Yeah, I thought the GAL read, no, it was the county attorney read it, sorry. No, there was, no. Mm-mm. No, what we have is Reuben himself objecting sort of after the fact during his allocution that he disagreed with the contents, the allegations contained in her report, and he says that her report should be disregarded as a whole. So there's minimal, there is some sort of, it's not what we would ideally hope for in an error preservation. Sorry.
But they don't contest error preservation. And, I mean, there are some things that go wrong at sentencing that you can raise after the fact without making a contemporaneous objection. But I think usually, if you're objecting to the inclusion of something in the PSI, that's an objection you have to raise at the time, isn't it?
That's how it's been treated, is under an ineffective claim usually, if it doesn't get objected to. So, yeah.
Okay. Does it matter that it was read? Does it sort of take it out of the PSI error preservation realm because it was read?
And it's sort of both, yeah, it definitely, it's in there twice, it's attached, but also, yeah, the fact that it's read, the court definitely relied on it and considered it in rendering sentence, so that's one distinction, correct.
Minute.
Madam Chief Justice, and may it please the court. Counsel, Ms. Nye. Sufficient evidence supports Reuben Schooley's conviction for child endangerment resulting in bodily injury. It is the circumstances that led up to the culmination of the events at issue that show this, that the unreasonable torture or the inflicted torment upon one child culminated in the resulting bodily injury.
Instructions say on or about June 12th. How far back can the jury consider some of that other evidence?
Well, the date is not an element of the offense, and Yao would be guiding on this point as well, that absent that date of the offense, it's merely to provide context and ultimately, in many cases, to speak to the jurisdiction of the issue. But as they argued within the discussion when the jury presented its question, a few days before or a week before wouldn't be unreasonable in this case.
The offense, but in the jury instructions, it says on or about June 12th. And so are they allowed to consider what happened a year or 2 years prior, or did the state really just charge based on the events right around the time that the officer was called to the house?
It would be correct, I believe, to say that the officer was drawn to the house for that final event, but what led to it and ultimately the depiction of the bruising as well would be a good indicator that it was before the event as well as what happened up to that point in time, indicated by the markings, for instance, after the shirt was ripped off, the scratches on AS's body, or the hit on her head as well, that kind of culminated in this event. Certainly, DHS's involvement, now HHS's involvement, I apologize, indicates that it was not only something for them to be aware of, as Ms. Nye pointed out, they attended therapy, but these kind of circumstances and considerations were something that was brought before the jury, was not objected to, and it was meant to provide context for how we got there. And that was to determine the reasonableness of the conduct by Mr. Schooley against his daughter, who at the time was only 9 years old. For this 2-year period of time, many circumstances led to the culmination of the event. The shirt that read, "Don't trust me," for instance, the wearing of a bell around her neck to indicate where she was within the house, calling her no better than an animal during the instance, and not being able to identify why he was using corporal punishment or physical discipline against his daughter at the time. In a sufficiency challenge, the circumstances matter here because they give us context to where Alice was in the room, where AS was, and where her father was as well during the instance. He did not see the reasons for which discipline would be necessary. He heard Tessica yelling. It was not AS who drew him out of his room when he was studying and interrupted him. It was Tessica. And with that, he still enacted physical discipline improperly and unreasonably against his daughter at the time. That included potentially slamming her head against a wall, as we heard from one of the witnesses who testified, the initial reporting witness. that led to her being hit on top of the head. And it is not disputed that he hit her in the head at some point in time, other than his potential misrecollection at that point, that he did not recall it himself, but everyone else did, including Tessica at the time.
To the sentencing issue, please.
As for issue 2, the statute is what it is. It says specifically that it provides for designated representatives. The issue here began in Lopez, for instance, back in 2015, whereas probably in that case represents likely the guiding light for the state's argument here, that the statute provides for a designated representative. Here, the GAL was likely the most designated representative to speak and advocate on behalf of the child in this case.
Also provide that, at least in 1A, the designated representative can provide the victim impact statement from the victim, but under, is it subsection E, the designated representative can only provide their own impact statement on behalf of the victim when the victim is otherwise mentally, physically, or emotionally incapacitated or incapable of doing it herself. What evidence is there and who gets to decide that?
Certainly, it could have been, and was in this case, the guardian ad litem.
The right person, but who was to decide that AS could not provide her own victim impact statement so that we can get to the point where the guardian ad litem is allowed to make a statement on her behalf?
The statute doesn't specify the clear procedure for it, but the statement in the state's position would be that the guardian ad litem was able to make that claim to the court as the representative and advocate of the child in the child's best interests. Her sole responsibility was to advocate for AS's best interest in this case, and in doing so, she mentions expressly in the victim impact statement or a report to the court, for instance, that
other than the victim impact statement statute under 91521 that allows the guardian ad litem to provide a report to the court at sentencing for purposes of sentencing?
Not that specifically, albeit their advocacy and their right to do so is manifested not only in the guardian ad litem provisions under Chapter 232 or 518, I believe, for child custody proceedings, but also within the victim rights statute as a prosecuting witness in this case.
A little bit about how does that match up with Scahill, where, and there we said that the GAL's activities should be devoted to supporting and protecting the child within, emphasis, the criminal case. It's not the GAL's role to attempt to bring about a result in the criminal case just because the GAL believes that result will benefit the child. And that does seem like what happened here with the recommendation of sentence. So can you help me square that?
Scahill's distinguishable for many reasons. By and large, the GAL's activities in that case were very hands-on. As the court pointed out in the decision there, the GAL actively asked questions, objected to the admission of evidence, and engaged in an outright trial proceeding on behalf of the child. Those activities, which are prohibited by statute under the prosecuting witness provisions, are not the same in this case as providing argument, for instance. And in Lopez, we'd identify that as well, because argument wasn't really the issue, but it was the active engagement within the trial process or ushering the case forward, in that case to a specific result, which was the conviction. Here, it was merely the expression of the victim's impact that that AS reported contemplating taking her own life.
Reading the guardian ad litem's report to the court, I agree with you that, first of all, I agree that a victim impact statement from a guardian ad litem where the child is unable to make one, that's okay. And I agree with you that aspects of this seem appropriate for a victim impact statement. But what about sentences like this? Guardians ad litem can help the court fashion a sentence that is both positive for the offender and psychologically rewarding for the child. I mean, that's kind of going beyond the role of a victim impact statement, isn't it? That's like the GAL saying, I'm kind of an expert. I can help you do this.
It certainly is an odd expression of the GAL's role. It likely mirrors more so the 232 provisions for which she was also appointed, or in the child in need of assistance proceedings as well. but it wasn't an improper or illogical application of her responsibilities in this case. Both in Lopez and in Scahill, there was a recognition that many of the activities of a GAL or responsibilities and duties of a GAL start or carry over into a criminal proceeding, albeit there's some limitations.
That the GAL cannot introduce evidence into the criminal proceeding?
Yes, that's correct.
In this case, I believe the GAL referenced a lot of conduct and other things that were not part of the trial and put into evidence during the sentencing hearing things that the judge otherwise would not have been aware of. Isn't that right?
I would disagree to an extent. Certainly what happened after the verdict when AS remained in Mr. Schooley's custody and the continued impact of his abuse and how it manifested was not necessarily what the trial pertained to, but victim impact statements are meant to be an unabridged expression of how a crime impacted the victim. And in this case, it carried through after the fact and ultimately led into AS's removal from Mr. Schooley's home.
It seems like this may have to be case by case, I'm not sure, but unless I'm mistaken, the impact statement is actually, isn't it entitled report to the court?
Yes, it is.
It's not titled as a victim impact statement. I think the GAL makes clear that it is her view of the facts of the case and not necessarily the child's view of what should happen. And then she introduces evidence that's not in the trial record. So you really have somebody, an independent person, as Justice Mansfield read, who's just opining on what the appropriate sentence should be, which is kind of the judge's job, right?
Fixing the sentence would be the judge's job in this case, yes. But the GAL, as an officer of the court, was permitted to make argument on what she believed was in the best interest of the child she was charged with representing and advocating for.
Of whatever the child said in the victim impact statement. So
It could be, yes. So, but we did not have AS provide her own statement, we being obviously.
Part of the, I mean, that's part of the issue. It seems like the GAL was very much doing a Chapter 232 kind of a recommendation, but this is a criminal sentencing. And so if the statutory authority for her to be there is under 915.21 and contemplates that the victim make her own statement unless she's incapable of doing it, it seems like there needs to be that process for the victim. And so why is it that the victim didn't make her own statement, or where is it that it says that the victim was unable to? She wouldn't have had to come to court. She could have made a written statement, and then the GAL could have read that. Why is that not the proper process here?
Certainly, it would be a limiting process here because a designated representative is permitted to provide a victim impact statement on behalf of a victim should they be so designated as.
If they're incapable. So in Lopez, it was a 2-year-old child. So by age, that child was incapable. What made AS incapable here?
Lopez would be distinguishable because they weren't appointed in a criminal case proceeding necessarily. Here, they were because AS was a prosecuting witness. The GAL was charged with representing her interests as well within the court case.
The designated representative. But under sub E, the victim is still the one that is supposed to, no one can, it does not provide for the representative to make a statement on behalf of the victim unless the victim is incapable herself. And so where is that in the record that she's incapable herself to have made the victim impact statement, so she needed one to be made on her behalf?
Largely came in through the GAL's own statement or report to the court, however we would coin it. That is because she said that it would be emotionally traumatic, that she was not in a good place to be able to come testify against her father, that Mr. Schooley specifically had continued his abuses, and it led to and ultimately culminated in a 9-year-old or 10-year-old child.
Their statement that he had continued his abuses, was that unproven criminal conduct that violates all of our other cases that talk about subsequent unproven criminal conduct?
It did not violate the unproven criminal conduct provisions here simply because it spoke to the familial breakdown in relationships that were, one, already covered in the PSI in this case, and two, duplicated by Mr. Schooley's own comments in his statement or allocution to the court. So,
You at all, the 232.2 sub 25, which is GAL definition, sub 8, talks about different reports and things. And the last sentence is, a written report shall be submitted for each court hearing unless otherwise ordered by the court. So is that something that was relied upon? Was there any discussion in the record about why she submitted it?
There implied a discussion as to how she crossed over between the two cases. That would speak to her being appointed to represent a prosecuting witness, but absolutely, she was responsible for reporting to the court, to the juvenile court specifically, and that carried over in her responsibilities because as an appointed GAL under the prosecuting witness provisions, she had to be the same guardian ad litem in both proceedings. So we are able to refer to them both because they're read in conjunction in many ways as well. Now, that may well be limited because the responsibilities that a GAL in a criminal proceeding in this case were and are expressly limited by statute. Here, that included not being able to direct or cross-examine witnesses or introduce evidence and engage in the trial process. But in this case, Mr. Schooley was already convicted, and Mr. Schooley was already found guilty by a jury of his peers. What remained was sentencing, and PSIs are meant to evaluate the full scope and breadth of a criminal defendant's situation, as well as the impact on a victim in that case as well.
Error preservation, failure to object issue.
Absolutely. It was my error to potentially or theoretically concede error preservation, but speak to the Granberry issue later on. And while that may have been inartful, and it was inartful to not include it in an error preservation component, Granberry was included for specifically being able to permit the evaluation and consideration of the unobjected to PSI information. And
It was actually spoken at the sentencing?
see that my time's expired? Is it okay if I answer? It likely does not matter that it was spoken at a criminal hearing, in this case sentencing, because it's required to be said at sentencing in open court for the most part. It could be written, but it was likely meant to be read as well. Here, that is exactly what occurred. A verbatim statement was read. That statement was the guardian ad litem's report. And that report was both a victim impact statement and ultimately a recommendation. As Justice Mansfield pointed out, maybe it crossed over, but a duty of a guardian ad litem is meant to be broad to represent and advocate for the best interests. And what we call it wouldn't necessarily speak to or limit it to being able to be mentioned at the sentencing hearing out loud and on the record versus just simply filed in the electronic record as well. And because of these factors, this court should affirm Mr. Schooley's conviction for child endangerment resulting in bodily injury. Thank you.
Come back.
I'll start with some of the guardian ad litem issues. The problem with what the guardian ad litem did in this case is exceeded that she was promoting a specific sentence. She had been appointed, and within those statutes, she was there to promote the protect the child and promote the child's interest. But that, that's crossing the line, as you said, Justice May, sort of the Scahill line is she can't advocate for a particular result. And pushing for a sentence is a particular result.
Happens all the time in victim impact statements. They always, close with, so-and-so, the defendant should, receive a long prison sentence.
A victim impact statement. This was her sentencing. This was a prosecutorial-minded sentencing recommendation. It was legally founded. It wasn't, people all the time, victims all the time say things in victim impact statements that are not properly, considered in a sentencing decision and, say all sorts of things. But judges know not to consider that. And often you see on the record the judge says, it's
Harmless, perhaps? I did find it in the transcript, page 13 of sentencing. The court takes a number of factors into consideration: maximum opportunity of rehab, protection of the community, the prior record, which isn't significant, employment circumstances, nature of the offense. And in the PSI, the court finds, as suggested by the guardian ad litem, that probation would not be an adequate deterrent, blah, blah. For all these reasons, the court's doing such and such. Didn't he have a lot of other reasons and not just reference to or reliance on those statements by the guardian ad litem?
Our cases about improper factors, the court doesn't consider how much that improper factor may have, if it tipped the scales, if it didn't tip the scales, they don't, the appellate court doesn't weigh in on that and try to second guess, would the judge have given the same sentence without that improper factor? It's, if it played any role.
As suggested by, isn't that different than just plain following garden ad litem?
I respectfully disagree that it is. I think it's the same, that he's saying, her suggestion was, he needs to go to prison to be deterred, and that was firmly rooted, even if her statement was allowed, on this unproven conduct of what happened, what she says happened after trial. So even if the guardian ad litem should be making a statement in a sentencing recommendation, which I disagree with, it's still, her deterrence argument was based on his actions, his alleged actions after trial, and that's what the court was relying on.
Job to look out for the child's interest and protect the child, and her opinion in that role is that the child's not safe if he's out free. What's wrong with her advocating for prison?
Line is because advocating for prison or a very specific sentence is a result, is a prosecutorial argument, and ultimately should be up to the judge. But it's also that she can advocate, if she can make a sentencing statement at all, to come in and say the child needs to be protected from the defendant, or the child needs to not have contact with the defendant, the child needs some space, or in a different case, the child needs to be reunited with the defendant. She can express the child's needs and what circumstances that would benefit the child, but stop short of making a sentencing recommendation. And then the court can take those factors into account and then fashion a sentence that, to whatever extent the court deems.
I thought I remember reading, and I don't have it in front of me, I thought in the GAL report she said, in terms of protecting the child, she thought, in the short term at least, probation or prison would be equally effective. Am I misremembering that?
Remember her only saying he needed to go to prison because he would do this again.
Okay. If he doesn't go to prison or get a stiff punishment, then he may do this again and again at a future date. But I thought there was some reference that probation might be sufficient to protect the child given the 232 proceedings.
Finding that he rejects her claim that the child can't be made safe outside of prison, but he says deterrence, he'll do this again, deterrence requires prison. I do want to push back, if I have a second, on who gets to designate the beneficiary if the child is unable to testify. Thank you, sorry. And the statute on the victim impact statements, this is meant to be broadly construed to effectuate rights of victims, and I would assert it's the victim's right to decide whether, this is meant to give a voice to the victim, and that, usually means the victim comes in and speaks or gets to express themselves and their wishes and their harms somehow. But it also is the right to not make a statement at sentencing hearing. And so that's why I think it's the victim who gets to designate the beneficiary. I think that's what makes sense. If you have a victim who we have a record that is incapable for mental or physical reasons, or it's too young, then maybe a parent can do it or someone else. But yeah.
A parent, I don't know where I saw it in the record. I tried to find it real quick. She doesn't have a mom in the picture. And so when you say if they're mentally incapable or whatever, we're talking about a kid. We're not going to go to a kid and say, do you think somebody else should make the statement on your behalf? Doesn't it seem reasonable, all of my experience with the guardian ad litems, that that's part of their job, is to make decisions like that? Like, I need to speak for the child on this one?
I think they need to be designated. I think we need something in the record that shows that the child, because she was able to testify, she was intelligent. Like, the record shows,
After testimony, though, something happened, and if it's in the record or in the GL report, I cannot remember, but something happened. I don't know if it was some comment by the girl, or I think she went back to dad after trial, but before sentencing, right?
throughout trial.
Isn't it reasonable to assume that the guardian ad litem said enough, and she made that call on her own, and that could be given some weight? And by the way, she is definitely a designate, right, as a guardian ad litem?
sorry, I keep saying beneficiary, designated representative. She's a representative of the child's interest. She's not a representative in the way an attorney is, but I still think it's the victim. You know, she may be a child, but if she doesn't want to, for good reasons or bad reasons, if she doesn't want to give a statement and doesn't designate someone else to make that statement for her, that's her right. That's her prerogative, even if she's a child.
A child, oftentimes the person that they probably should scream from the mountaintops about is the last person on in this earth that will ever say anything negative. Often when we terminate parental rights through the court system because of heinous behaviors, they want to go back home. Even if we terminate parental rights and the kid they go back home. So I don't think it's unreasonable at all to assume that that decision should not be left up to a 9-year-old who's been traumatized.
I think it's heartbreaking, but it's, you know, that's children, you know, that's the way the statute is. Sorry.
Question, are you aware of any cases where we've talked about the process under 91521E for determining when a victim is incapable of making their own statement?
No, I know it gets talked about a little bit in Lopez when it was someone young, so there's no record at all in this case that she was incapable or, you know, we know she was been traumatized. That's
in her report. Would that be enough?
It would be traumatic, but not that she has any wishes on whether she wants to come or if other methods have been tried. All right, thank you very much.
Versus Schooley is hereby submitted, and we'll have just a couple minutes here to allow the lawyers to switch out. Next case is State versus Flynn.